State of Michigan versus Anthony Harris. Case 2405880701. Today is the date set for a bond redetermination hearing. Appearances, please.
Thank you, Judge. Steve Vincent for the people.
Jessica Shab on behalf of Mr. Harris. Mr. Harris, please state your full name for the record again.
Anthony Kevin Harris.
Thank you.
All right, today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable. Ms. Scheib, as to bond.
As to bond, Your Honor, he has 5 kids, lifelong resident of Detroit. He says this is the girl knew he was at the house. She lets him always stay there, but this is what she does every time she goes through his phone and sees something she doesn't like. She calls the police and makes these allegations and gets him locked up, Your Honor. He did go to Dorsey Culinary Arts School. He does take high blood pressure medication. He was arrested while walking on the street. He's employed doing landscaping. He understands he needs to make it to all of his court dates. Lives with his father when he's not staying at that house. Respectfully asking the court to consider a personal bond and no contact with that address.
All right, Mr. Vincent, as to bond.
Judge, this is with all the respect in the world, but I really don't understand what's going on here. Defense counsel just talked about this defendant being with the complaining witness. He has a no contact provision with an ongoing case right now with this complaining witness. But yet now we know he's making contact with her, which is a direct violation of the case that's going on right now. That case number is 24044720001, and it's a B&E for illegal entry. And it's with the same complaining witness. And one of the bond conditions is, well, 2, no contact with the complaining witness or the residents. But now we have here that he's commiserating with them, at least just based on what we just heard. In addition to that, he's on active probation right now for domestic violence. He pled guilty on May 20th of 2024 with a different complaining witness. That was with a different girl, a girlfriend that he had at the time. And Judge, we also have, in addition to the second offense notice here of the DV, which I just talked to you about, we had a DV that was previously deferred out of Clinton Township. And that was about 10 years ago. And then we have these allegations. I mean, we're talking about 20-year felony regarding this. I'm not even going to get into the allegations because everybody sees, you know, based on the investigator's report, the allegations, but this is just an ongoing perpetual thing that this defendant is doing to this complaining witness. I mean, quite honestly, it's scary at this point. So respectfully, Judge, we're just going to ask you to continue this bond.
Your Honor, may I briefly respond?
Sure.
So, Your Honor, whatever no contact order there is in another case, that's in another case. Now, obviously, he's supposed to follow all court orders, but we see this all the time where there are parties who they have PPOs against each other, no contact orders, calling police on each other, and then they're together, sleeping together, riding in cars together, doing whatever together. We see it all the time. Now, it's still wrong, and my client has to follow court orders. But in this case, he's being charged with home invasion, which means he didn't have permission to be there, but he did. And what we also see is that there's a pending case with the same person for breaking and entering, because that goes with what my client said, that they're always staying together. And every time she goes through his phone, she calls the police and makes the same allegation. So it's a cycle. And whether, you know, whatever's going on between these parties, clearly they're not good for each other, because if she keeps making these allegations against him and he keeps ending up in jail and she keeps telling him, oh, come over, you can stay here. And then she's mad and then she calls, he's the one ending up in jail. He's the one violating, you know, any pending court order. And he knows that, but he's being charged with a home invasion right now. It's an allegation, but Your Honor, we're here for bond redetermination purposes. And what I'm letting the court know is that according to him and the cycle that we're seeing, she lets him stay there. Now, the court obviously is going to say you had a no contact order, and he understands that. But when it comes to the home invasion, that's not what's happening here, Your Honor. So respectfully asking the court to consider a reduction in the bond or a personal bond and absolutely no contact with her or her address. And if the court is not inclined to do that without a GPS tether and house arrest, then we understand that, Your Honor.
All right, bond is going to remain the same. I've had a chance to review the investigator's report as well as hear arguments. These are two different cases. There is the defendant is charged with B&E breaking and entering a home or illegal entry without owner's permission. That's a misdemeanor. The complaining witness in that matter is the same complaining witness in this matter. There is a no contact order associated with that. And while these are separate cases, you know, when I make a determination as to bond, I have to determine, if the defendant, if I can protect the safety of the public without a cash bond, or do I need a cash bond to make sure that this doesn't happen? And what this tells me is that there's a court order ignored. Now, to your point, this might have been a with permission situation. These are the allegations, and I don't pretend to understand exactly what's happening on this. But what I do know is there was a court order not to go to the house. This incident happens at the house. The charges are the charges, and I have an understanding now that that previous court order was broken. So I'm not going to take that chance again and set a personal bond. Bond is set intentionally unaffordable in this matter, and that bond is going to remain the same. There's clear and convincing evidence at this point between the assault of history and the violation of that no contact that cash bond is necessary. Mr. Harris, sir, your next date is going to be August 21st, 2024 before Judge King. And that concludes this hearing.